So hello everyone, this is Washington Arbitration Week, Wednesday, 1st December, Thursday, 1st December. We are having a fabulous panel on space law, dealing with issues concerning a huge question, which may be one of the questions that when any investor state tribunal deals with a space law issue, I can with confidence say that they will look into this question. I mean, no doubt, whether some of the space related assets are investments under investment treaties and other instruments. So we are very happy to be doing this panel with our hosts here at Boies Schiller, and my mission here is simply not to steal anybody's thunder, but only to introduce Ben Love, who is a partner of the Washington, D.C. office and also the New York office, and is heading the international arbitration practice. And Ben, among many things, he has represented parties in investor state arbitration and in commercial arbitration, and is very much a interested person academically and also business-wise in space law-related issues. And I also would like to thank Laura. I'm not going to lose her, but she has also been a force behind the space law issues, and we've had her and her colleagues and her organization in Washington Arbitration Week, in World Arbitration Update, and now it's a pleasure to have her again. And with that, I'll give the floor to Ben.
Thank you very much, Jose. And thank you to all the organizers and supporters of Washington Arbitration Week. At Boies Schiller, we're very happy to be partnering up to present this program today. So we have with us 4 excellent speakers. Sitting here in the room to my left is Ernie Chong, who is a managing director with FTI Consulting and based in Denver, Colorado. Ernie specializes in all aspects of the space value chain. Among other things, he works on due diligence and merger integration matters, and has over 20 years of experience in the space and telecommunications industries. So Ernie is a true industry expert in the subject matter of today's panel, and we're very happy to have him. Thank you. And then to my far left is Peter Pulasic, who is a partner in the international arbitration practice at White & Case here in DC. Peter has extensive experience in both commercial and investment arbitration in a variety of industries, but including most pertinently for this panel, the mining industry. So I think Peter will give us some words later on mining the moon and other places in space. Peter has law degrees from Charles University in Prague and the George Washington University Law School as well. We also have with us Laura Yvonne-Zielinski, who's with us virtually today. Laura has law degrees from Sciences Po in Paris and Columbia University, and she currently practices international arbitration with Collin Knight in Mexico City. She has experience in a variety of international proceedings, including before the Iran-US Claims Tribunal, the International Tribunal for the Law of the Sea, and the International Court of Justice, in addition to extensive experience in investment and commercial arbitration. Importantly for today, I should point out that Laura is also a founder of the Space Arbitration Association and is a true leader in exploring space arbitration topics in this field. We also have with us Philippe Goudenot, who is dialing in. Are you in Paris, Philippe, or are you in another part of France?
No, I'm on the East Coast of the United States.
You're in, I had no idea. I thought you were calling in from France. So, but also dialing in remotely. He is a French-American national security and compliance attorney, and he has represented global aerospace and defense companies in the US, Europe, and around the world on anti-corruption and global trade matters and foreign investments for over 30 years. Philippe is currently serving as a designated official and independent monitor for Airbus under a consent agreement with the State Department. So we're very happy to have Philippe and his expertise with us today. So I won't go into the topic much myself because we have these wonderful experts with us today, but I'll just start with a question which I'll pose to you first, Philippe, which is, why is it important to discuss the protection of space assets?
So thank you, and very nice to be with you all. Just a general disclaimer. Obviously, my views are my own, and I'm not speaking on behalf of Airbus nor on behalf of the State Department, of course. Why is it important? Well, as you all know, probably, I mean, space activities have grown exponentially in the past several years. Just to put things in context and just to take a few practical examples, speaking about Airbus, so you have a range of, let's call them space objects, starting with commercial telecom solutions. So just one example, OneWeb, which is a system composed of 900 satellites. You have Earth observation, multi-satellites programs, such as the Pleiad Neo, geopositioning constellations, such as Galileo, communication satellites, such as, which is very interesting. I actually had the chance of visiting an Airbus site in the UK a few months ago, and the program is named Zephyr, and this is public information. So it's an high altitude platform system. So it's like a glider, and the purpose is to provide telecommunication services, including internet services, to low density areas such as in Africa. So you have a growth, significant growth in space objects in space, and then you have launchers, obviously. So I think that one of my distinguished co-panelists will talk about the Mammotus case later during the discussion. You may remember Sea Launch, which was a joint venture back in the 90s between the Russian, the Ukrainian at the time, which is interesting, and the US. Established to launch satellites. So you have basically a significant increase in space objects, and the big shift is that all these systems, if you will, used to be government-owned, state-owned systems, and this has shifted in the past 10 years or so, and now the states are not so much the owners of the systems, they rather buy a service. So there's been a shift between state ownership and governments buying the service instead of owning the platform, and this changes the parameters for all investors, of course. So for example, the International Space Station, which was used to be operated by NASA, is today operated by a non-profit laboratory. So that has been a big change. And of course, this has implication in terms of investment. Back to you, Ben.
Thank you, Philippe. That was it's a very interesting overview. Ernie, do you have anything to add to that?
Thank you so much for having me today, and thank you, Philippe. So just to sort of elaborate of how we got to where we are today. So roughly about 5 years ago, there were roughly about 1,500 active spacecraft that were performing specific missions. And that consisted roughly about 60% institutional customers, which are civil agencies, national security agencies, Defense Department, and things like that across the globe. And roughly 40% of the market was commercial. So communication satellite, Earth observation satellite. So this is 2017. Today, we have roughly about 5,500 active spacecrafts flying today. And the ratio has completely switched. So we are now only about 25% institutional spacecrafts and 75% commercial spacecraft. And why is that the case? Well, historically, space has been an institutional domain because the cost of access to space was tens of thousands of dollars per kilogram for an object to be launched into space. And thanks to reusability, thanks to SpaceX, we're now looking at less than 5,000 kilograms, less than $5,000 per kilogram to low Earth orbit. So historically, business cases that did not close previously are closing. And so there is a new sort of found renaissance of low Earth orbit commercial activities happening across the globe. So to be a little bit more specific, so Starlink, which is a SpaceX venture providing internet connectivity, has 4,400 spacecraft for their first generation. Philippe already mentioned OneWeb. You know, the first generation is 648, but they're talking about the second generation consisting of thousands of spacecraft. Amazon Kuiper, yet to be launched, at least 3,200 spacecraft. The Chinese constellation, China's SatNet, has 13,000 spacecraft. It's in the process of being developed. There is the Koreans, Hanwha, 3,000 spacecraft. European Commission just passed the approval to launch the Secure Comms Network. That's 170 spacecraft. So if you talk about sort of where the domain, where the industry is right now, this was almost unfathomable roughly 5 years ago. But now this is sort of a matter of reality. And there are commercial enterprises that are putting billions of dollars with the help of some state funding to contribute and grow the low Earth orbit space economy.
Thanks. Yeah, thank you, Ernie. And Laura, I think you were going to highlight some trends from the Space Foundation Space Report.
Yes, thank you very much, Ben, also for the very nice introduction and for inviting me. So yes, I want to underline what Ernie and Philippe have just said, maybe with a few recent numbers that were contained in the Space Foundation 2022 Global Space Report. So according to this report, the global space economy reached $469 billion in 2021, with the commercial space sector seeing a 6.4% revenue growth since 2020. And most of the money generated by the space industry in 2021 corresponds to the commercial sector, with more than $224 billion coming from products and services delivered by space firms, and nearly $138 billion spent on infrastructure and support for those commercial enterprises. And this is contradicting the numbers that Ernie has just said. So they might be more recent, because with all of the launches we are currently seeing, things are changing very rapidly. But according to this report, over 90% of today's spacecraft are now commercial. And it also mentions that in the first 6 months of 2022 alone, 1,022 spacecraft have already been launched. This is a very significant growth. And I think now we have a total of 5,500 active spacecraft in space, although this number again is changing very quickly. And I just want to say that I think this growth is going to continue, because according to another study done by Euroconsult that was published in November, global government space exploration investments will reach $31 billion by 2031. So we can expect to see a lot of growth in this area, which is why this panel, I think, is relevant. Thank you, Ben.
Thank you, Laura. So I think we've seen or heard so far that the space industry is experiencing rapid growth. Peter, I had promised that you would address mining in space. So how is this growth impacting the mining sector in particular?
Thank you, Ben. It's a pleasure to be here. So just continuing on this theme of things that were unimaginable just a couple of years ago, and now are a reality. So I would add to the list the emergence of private sector activities aimed at exploring and exploiting space resources, which today sounds like science fiction, but we might be on the cusp of something happening, and developments that will eventually result in private mining in space. If we let me give you how this might come about. So first, in the last couple of years, there have been a number of near-Earth asteroids identified that are mostly metallic and contain cobalt, iron, nickel, platinum, gold maybe, and that has led to the emergence of private companies that seek to develop the technology to mine them and bring those materials back to Earth, such as Astroforge in the United States, the asteroid mining company in the United Kingdom. Second, the existence of water on the moon, which again was confirmed in the last couple of years, raises the possibility of producing hydrogen on the moon and using the moon as sort of a refueling station for further development and exploration of space, and that gives rise to the possibility that maybe there would be private sector involved in that in a similar way as we see that, for example, in the launch industry, which again, 20 years ago, I don't think anyone would have imagined that we would have private taxi basically going up and down the orbit. Third, there might be resources on the moon itself that might be worth exploring. So just this fall, you might have seen the news that the Chinese Chang'e 5 mission on the moon discovered a new mineral on the moon. It's called Knight now, and it contains helium-3, which is an isotope of helium that is very rare on Earth, and it has been identified as a potential fuel for nuclear fusion. For those who are interested in that as maybe the future energy of mankind, this is another potential area. And I would add also, today was the scheduled day for the launch of a Japanese privately owned lunar lander. They canceled it again, unfortunately. Otherwise, this would be a very opportune time for us to be discussing these things. But it's a privately owned lunar lander. The mission is to land on the moon, and as part of the mission, the company called iSpace has a contract with NASA to mine regolith, the surface layer of the moon, bring back samples and sell them to NASA. So once that happens, that is going to be the first instance of private mining on the moon, albeit at a micro scale. And also in connection with that, some states, notably the United States, have made it a part of their space strategy and a matter of their official state policy to support the commercial development of private space activities, including space mining. And so for the United States, that's true under or that was true under the Trump administration. It is also true under the Biden administration. And so to give you one example, in December 2021, the White House released its US Space Priorities Framework. And that's a policy document that says that it is one of the United States priorities in space to foster the development of the commercial space sector, including specifically the recovery and use of space resources. And so we are seeing this movement on the commercial side, but also on the state side, where countries are asserting as a matter of policy that they want their nationals and companies to be engaged in space mining. What comes with that is that There is a regulatory framework developing in those countries to support that. We might see government support going into those areas, and maybe 10 years, 15 years from now, we will be sitting here and space mining will be a reality. And what comes with that, of course, is the question, is it legal as a matter of international law to be extracting those resources? And what do we do if the interests of private parties and states clash in space? How do we secure a legal regime that will enable private companies to take on the risk to go out there and buy?
Thank you, Peter. That's fascinating. So we're not to mining on the moon just yet, but we're close. Is that the takeaway?
Mining this much, if it works out with the Japanese mission, but it may be.
And so you had mentioned how this activity is regulated, and I thought we might turn to Laura, who could give us a background on the international framework for regulating activities in space.
Yes. One second, please. Yes, so space activities are mainly governed by 4 space treaties that have been developed within the United Nations Committee on the Peaceful Uses of Outer Space, short called UNCOPUS. And those treaties are the 1967 Treaty on Principles Governing the Activities of States in the Exploration and Use of Outer Space, including the Moon and other celestial bodies, which is called in short the Outer Space Treaty. Then we have the 1968 Agreement on the Rescue of Astronauts and Space Objects, the Rescue Agreement. We have the 1972 Convention on Liability in Outer Space. And then we have the 1976 Convention on the Registration of Space Objects. So those are 4 treaties that have been widely ratified and constitute the main basis of international space law. There's a 5th agreement called the Moon Agreement that has been ratified by very few countries and by none of the major spacefaring nations. So it is interesting to look at, to see what has been thought of in terms of rules for exploiting the moon and other celestial bodies, but it is not binding on many countries. So as I mentioned, there are 4 main treaties, and really the main one is the Outer Space Treaty. It is sometimes even called the Magna Carta of International Space Law. And it is the most comprehensive of the 5 treaties in the sense that it sets out the main principles that is governing the use of outer space. And I will mention just some of those principles quickly, because I think they will be important for our discussion. So under this treaty, the exploration and use of outer space shall be carried out for the benefit and interest of all countries. And it also states that outer space cannot be subject to national appropriation. So I think Peter will say a few more words about this afterwards, but in the context of what we just heard, that a private company will mine the moon, this is an interesting principle that is contained in international space law. The Outer Space Treaty also states that state parties to the treaty shall bear international responsibility for national activities in outer space, and that each state party to the treaty that launches or procures the launching of an object into outer space, and also each party from whose territory or facility an object is launched, is internationally liable for damage to another state party to the treaty or its natural or juridical persons by such object or its component parts. So again, this is a very important principle because it states that if you launch an object into outer space and that objects or its components which includes space debris, damages another object, the state will be liable. So in addition to these treaties, there have been several resolutions of the United Nations General Assembly, and they are in theory non-binding, but some have been recognized to constitute customary international law. And especially the 1961 resolution that recommends that states register their space objects with the United Nations as part of an international registry. So registration of space objects is mandatory for those countries that form part of the registration convention, but under this GA resolution, it is also recommended for all other United Nations member states. And then independently of the pure space treaty, I think it is important to be aware of the International Telecommunication Union, which is a specialized agency of the United Nations that is headquartered in Geneva, and it is managing all radio frequencies and the use of the Earth's geostationary orbit. So in practice, if you want to launch a satellite under the ITU rules, it must be coordinated with neighboring satellite networks to avoid interference between the frequencies that are used. And for our later discussion, it is important to know that this coordination process is often recorded in so-called coordination agreements between the different operators that set out which operator will use which frequencies, so that there's no harmful interference between the two. And before I will stop, just one short mention of soft law, because as I just mentioned, so states are liable for damage caused by their space objects. This is becoming an increasing problem because there are more and more satellites, and also more and more defunct satellites and parts of satellites called space debris. And unfortunately, we do not yet have a binding treaty regulating the mitigation of space debris, but there is a non-binding international agreement in the form of the 2007 United Nations Space Debris Mitigation Guidelines that are generally accepted as constituting best practices in this area. Thank you.
Thank you, Laura. I have one follow-up question, which is with respect to the obligations you described that are hard law, that are not soft law. What enforcement mechanisms are available to resolve disputes or even address disputes?
I think Peter will speak a little bit more about this afterwards, but basically there are no dispute resolution mechanisms contained in the space treaties except for the liability convention that has a mechanism called the Claims Commission, but it is also like its decisions are non-binding. So this is a big problem of international space law. The Outer Space Treaty refers to the dispute settlement mechanisms under international law. So one would assume that this refers to international arbitration, to the ICJ, to other mechanisms, but also all of the dispute settlement mechanisms contemplated under these treaties are state-to-state mechanisms, so they do not apply to private parties, which is why arbitration is an important aspect to consider for space operators. But I think we will talk about this a bit more later on.
Of course. Okay, well, thank you, Laura. That's very interesting. And Peter, would you mind addressing other regulations of space activity at the regional and national?
Sure. So let me just say the Outer Space Treaty, which really is the foundation of international space law, is important and key because all the major spacefaring states are parties to it. So although it dates to the 1960s, the United States is a party, as is China, Russia, and many other nations. It is really a global treaty. It does not, however, address clearly some of the key questions that come up when we consider private commercial activities in space, such as, is it lawful under the treaty to extract resources and sell them? And different countries have taken different views on this. So just very briefly to outline the status of where we are, we have a block of countries aligned around the United States. They have adopted what's known as the Artemis Accords. The Artemis Accords are a set of agreed principles for the civil exploration and use of the Moon, Mars, and celestial bodies. And it elaborates the principles that the countries that subscribe to the Artemis Accord agree upon would guide private space activities. And among those is the principle of or the concept of the so-called safety zones. These are areas surrounding activities on celestial bodies such as the moon. The purpose of a safety zone is to avoid harmful interference within the safety zone by other actors or other signatories to the Artemis Accords. And the Artemis Accords expressly state that safety zones are to be used, among other things, for the safe and efficient extraction and utilization of space resources. So not only do the Artemis Accords expressly recognize that in the view of the parties to the Artemis Accords, it is lawful to extract space resources for commercial profit. They set up this mechanism, which is like a nucleus of a mining regime, where a safety zone, in part, is designed to allow not only the safe extraction but also an efficient extraction of space resources. So that might be like the start of a semi mining regime for space. There also are, and we can contrast that with the Moon Treaty, for example, which one of the main spacefaring countries are parties to that, but that has a completely different concept, which is that space resources are to be exploited for the benefit of all countries, and there needs to be some kind of a benefit sharing mechanism. So completely different idea from the notion that space is open to commercial exploration. And just going back to the Artemis Accords, the other parties to it include Brazil, Canada, France, Italy, Israel, Japan, Mexico, the United Kingdom, and a number of other countries. Russia has expressed stern opposition to the Artemis Accords. Came out. Then, if we look down to the national law level, a number of countries have adopted their own legislation, which is designed to set up a legal framework for their own national to make it lawful or to support, as a matter of national law, the space or commercial space activities of their nationals. So one prominent example is the United States Commercial Space Launch Competitiveness Act of 2015. That act provides that U.S. Citizens engaged in the recovery of a space resource or an asteroid resource shall be entitled to the recovered resource, including to sell it. So again, the same idea implemented in the national law of the United States, and it basically gives or enables U.S. nationals to, as a matter of U.S. law, to go out to space, mine it, sell whatever they recover, and keep the profits. Another example, Luxembourg seeks to position itself as a hub for space companies and space law activities, and it has adopted a number of laws designed to enable, again, as a matter of Luxembourg law, private exploitation of space. It is along the similar lines as the United States approach. Thank you.
Thank you, Peter. Well, I'd like to move on to discussing how to protect the private investments, but I thought first I might give Ernie and Philippe a chance to add anything they'd like to the topic of the legal framework governing space activity.
I'm happy to jump in. Part of the challenge with the legal framework is that people are coming up with new use cases for space every day. Things that we've never thought of before, somebody's thinking of doing. And so the framework is almost just guiding principle, but the actual details of actually how you address specific use cases has to be defined on an ongoing, and it's an evolution. And so it's one of these situations where you can't see that far ahead. You just can't. It's sort of best guess as to what may arise, right? So specific example, Russia conducted an ASAT test last December in 2021. And some of the satellite companies that I'm aware of, this is public information, had to maneuver their spacecraft out of the debris swell. And the International Space Station had to essentially do an orbit raising maneuver to sort of dodge the debris. Well, what is actually happening with these spacecrafts, these celestial objects, is that they're burning fuel to conduct these orbital maneuvers. And fuel costs money. And sometimes these satellite operators had not planned to conduct these type of evasive maneuvers to sort of mitigate conjunction risk. So fundamentally, by having to perform a number of these type of maneuvers, you are essentially shortening the lifespan of these spacecrafts. And so from a liability standpoint, from an international regulatory framework standpoint, who is ultimately, where do you collect that from, right? So from an investment perspective, investors say, hey, you know what? Do we sort of plan that into our business cases, thinking that, hey, we're going to have to, as there's greater congestion, we're going to have to, plan for these type of maneuvers and incidences? Maybe. So it's definitely one of these situations where you did not expect it 5 years ago, but you're starting to see things pop up left and right.
So to put it simply, it's simply impossible for the law to keep up with the level of activity or the level of new activity. Philippe, did you have anything to add to that?
Yeah, thank you, Ernie, and thank you, Ben. I think from beside the legal framework that was very clearly explained earlier by my colleagues, from an investor standpoint, I think it's important to keep in mind the regulatory framework. And although, as Yvonne mentioned, 90% or so of spacecraft are commercial, they are very, it's very close to their activities are likely to be, their existence and activity are likely to be treated as critical infrastructure and national security related. So let me explain. For example, launching sites are very often due to security concerns, potential cybersecurity attacks located on military installations. And satellites and satellite network systems will be likely treated as critical infrastructures, and as such, in the US, for example, subject to national security review by CFIUS, Committee on Foreign Investment in the US. So there was a case back in, I think, 2020, momentous, that was the acquisition of by a foreign company of a US-based company operating satellites, and this gave way to a mitigation agreement, I think. Recently, as we all have seen, the Biden administration signaled that the mere funding by foreign money of Elon Musk's Twitter should be subject to a national security review. So from an investor standpoint, I think I would pay a lot of attention, very close attention, and make sure I receive very sound legal counsel before making any investments in this area, because this is tricky. And just to add a last data point, there are instances where the transfer of ownership from a satellite manufacturer or launcher provider, Airbus or any other company, might not occur before the spacecraft is in space. So there is a launch, goes into space, and then the transfer of ownership occurs then, which is not easy from a liability standpoint, as you can imagine.
Thank you, Philippe. So let's turn next to mechanisms by which private actors who are invested in the space industry can protect their investment. You know, we've seen that the legal framework for space activity mostly governs relationships between states, at least at the international level. And there's some jurisdictions that have been identified, such as the US and Luxembourg, that have their own national frameworks that might provide some guidance to private investors. But what about investment treaties or just ordinary commercial contracts? What is their role in the protection of these space assets? Peter, would you like to start?
Sure, Ben, thank you. Excellent question. Let me start with the regime that exists under the UN treaties. So as Laura mentioned already, there is a principle of responsibility of the launching state for damage caused by their space object. But what is lacking is a binding mechanism to resolve related disputes and to award damages for whatever harm might arise from a space object. So the Outer Space Treaty does not contain a dispute resolution mechanism for that. What we do have, again, we are discussing the UN treaties now, is the Liability Convention, which does contain a dispute resolution mechanism of sorts. That's the claims commission that Laura mentioned. And the way it works is that the launching state is responsible for damage caused by its space object. The launching state in this, or space object and launching state in this context, means not only the state itself, but also objects launched from its territory. So if you think SpaceX, that is a space object of the United States because it's launched from the United States. So to the extent that that causes, damage, then that would trigger the provisions of the liability convention. The type of liability under the liability convention is differentiated based on whether the damage happens on Earth. In that case, it's absolute, or whether it happens outside of Earth, meaning outer space. In that case, it's fault-based. And the convention defines what is meant by damage. That's Article 1A, and that is loss of life, personal injury, other impairment of health, loss of damage to property of states or their persons, importantly. So if a space object causes damage to private property, that is arguably covered by the liability convention. Then Article 12 articulates the compensation that must be paid to compensate for such damage. And that will be familiar to those of you who are interested in investment treaty law or public international law. It kind of mirrors the Corso-Hector standard in that it refers to reparation that will restore the person to the condition it would have existed in if the damage had not occurred. And there is a debate going on among scholars whether there is consistency between those two provisions, Article 1 and 12, in that 1A, the definition of damage seems to be a little more limited than the compensation provision of Article 12. How exactly the liability convention would work in this context, we don't really know. The dispute resolution mechanism is basically a state-to-state process, where first there needs to be consultations through the diplomatic channels. And if that does not result in the resolution of the issue, then the matter may go to a claims commission. That's a quasi-arbitration process, but importantly, the decision of the commission is not binding unless the parties had agreed for it to be binding beforehand. To date, there has been only one one instance where the liability conventions, dispute resolution provisions have been triggered, and that was the disintegration of a Soviet spy nuclear-powered satellite over Canada in 1978. The debris fell onto the fortunately uninhabited portions of Canada's northern territories. Canada undertook efforts to locate the debris and to get rid of it, incurred costs of about 15 million Canadian dollars back then doing that, and then it presented a claim against the Soviet Union for damage under the liability convention and subsidiarily under general international law to recover those costs. That would have been a very interesting case because it's not clear whether that sort of thing is captured by the definition of damage under the liability convention. But how that would have turned out, we don't know, because the parties settled and Canada received a payment of about 3 million Canadian dollars, and that was it. Nevertheless, the convention might come into play. I think the example that Ernie gave is an excellent one, and it's not at all hypothetical. It may be that over time we will even see instances of actual physical damage to commercial satellites resulting from the sort of military test that Russia conducted when it destroyed the defunct satellite recently, and that caused a reshuffling in the constellation of the satellites that were in the zone of debris. So it is a possibility if something like that happens. I mean, it's kind of like a diplomatic protection type of claim, so it would require the home state of the investor or the private party to take on the damages claim, pursue it within the dispute resolution mechanism of the convention. And if you have a hostile country on the other end, you will not get anything that is binding. So it has its limitations. Let me just say a couple of words about investment treaties. So, the big problem there obviously is that they are territorially limited. So they only apply with respect to investments in the territory of the states concerned. And that raises the question, if we look up, where does territory end? International law does not have a clear definition of where sovereign territory of individual states ends and where outer space begins. There are a couple of possibilities. One is the so-called Karman line, which is 100 kilometers of sea level. Other definitions put it a little lower at 50 miles, which is around 80 kilometers above sea level. But what is pretty clear is that pretty much all of the activities that we are concerned about, including the lowest of the low orbit satellites, are beyond that line in outer space. And so those assets that are out there would not qualify as assets covered per se by investment treaties. However, it is conceivable, I think, that if a state acts in a way that damages a space object, a satellite, or impacts, the future mining operation on the moon, for example, and that has impacts on Earth, such as that it reduces the value of a space mining company's shares, or impacts of that sort. If that company is established in a jurisdiction that has a bilateral investment treaty with another country, one could conceivably make the claim that that investors from the other country would have a claim for damages against that host state, not with respect to the assets out in space themselves, but the company that owns the assets would be the covered investment. And one could maybe construct an argument that it does not matter. The harmful conduct of the host state does not need to occur within the territory itself. So when it comes to investments, space-related investments on Earth, and impacts of state conduct on those investments on Earth. There, of course, investment treaties are very relevant as with respect to any other types of investments. And there, in fact, have been investment treaty cases relating to state assets. Laura will discuss a couple of examples of those. I would say there that the bottom line for the space industry is that to the extent that you have cross-border investments, it is important to consider structuring the investment in a way that it would be brought under the protection of the investment treaty. And with that,
okay. So before we go to Laura to describe some of the cases that in this industry that we have so far, I wanted to ask you, with respect to the territoriality requirement, what would you think about a theory of territorial nexus? So the space asset itself, obviously is not in the territory of the state if it's in outer space, but if the state owns the rights to the orbital slot and has used those rights to launch a satellite program, to launch a satellite into that slot, everything that has to do with this particular investment, which is capital intensive, is controlled by that state. Might there not be a theory of territorial nexus with that state that would satisfy the territoriality requirements in the for covered investments under the BAT?
Yeah, very interesting question, and maybe I think it's something that might be argued if a scenario occurs where something like that happens and the investor is looking for ways to get remedy, and an investment treaty is really the only thing that they have. So possibly, I mean, I think it would bump into the meaning of territory as defined under the applicable investment treaty, and there I guess the state would argue, well, look, it's universally accepted, it's enshrined in the Outer Space Treaty that outer space is a non-sovereign space by definition. That's like the basic building block of outer space law. And so even though it might be a territorial nexus, you just cannot claim that that is the territory of any state. That would be the side of argument. But
we might be stuck here on Earth when it comes to
on Earth, but that's not to say that a different argument is not plausible, and it's definitely not to say that we will not see cases where this is played out and argued.
Okay, thanks, Peter. Laura, so let's just assume that we're on Earth for now. What cases have arisen in this sector so far in the investment treaty sphere?
Yes, thank you, Vin. So I completely agree with what Peter has said, but the way I see it, we can distinguish between investment cases that really refer to physical harm to assets in outer space, where I think the territorial requirement is controversial. And then we have investment cases related to the space industry that are very conventional cases in the sense that they deal with concession contracts or public contracts with the state, where actually the nexus to outer space is remote to some extent, because what's really at stake is not the physical harm physically in outer space, but if an investor signed a concession contract with a specific state, I think an argument surrounding the territorial nexus just because the subject matter of the concession contract is in outer space is not very relevant. And this is actually what we can see in the cases that have happened so far, which are basically 3. And in none of these cases, the territorial link was argued. So yeah, I mean, in the 3 cases arising out of 2 situations, and in neither of the 2, the link with the host state and the territory of the host state was controversial. So one of those cases is Eutelsat versus Mexico, which is a case I personally worked on. So I can't say that much about it, but it related to a provision contained in a concession contract that Eutelsat had with Mexico over the use of geostationary orbital positions. And in the concession contract, there was a provision saying that Eutelsat had to reserve a percentage of their overall satellite capacity for free to the Mexican state, which is a provision that dated from a long time ago, and Eutelsat was arguing that it was violating the fair and equitable treatment standard of the treaty. Unfortunately, Eutelsat lost that case. And the other two cases arising out of the same fact scenario are Davis versus India and Deutsche Telekom versus India. And those cases arose out of a contract with an Indian company over the leasing of S-band frequency band. And India canceled that contract, saying that it needed the S-band for its own security reasons, national security reasons. And that those cases were lost in part and won in part by the investor, because the tribunal decided that only part of the frequency band was needed for national security reasons, and the remaining part was decided to be a breach of the expropriation and fair and equitable treatment provisions in the applicable treaties. So we can see that there have been investment cases relating to the space sector that were not particularly controversial, in the sense that they were quite conventional cases, not so much focused on the outer space aspects, but on the regulatory aspects surrounding those investments. I think to the extent that we will see collisions happening more frequently, and maybe even see satellite operators having to conduct very costly avoidance maneuvers all the time, we might see cases that are more purely space cases, where I think all of the elements that Peter has mentioned will probably be argued. And before I stop, I want to say a few words about commercial arbitration, because if we talk about the protections of investments in outer space, I think it is important for operators to keep in mind that the dispute settlement mechanisms that are available are few. Space activities are highly technical, often confidential, and subject to export control regulations or other specific legal aspects. And national courts might not be that well equipped to deal with those cases because of the language barriers, the public character of national proceedings, and maybe also the lack of specific space experience of national judges. So international arbitration is an important option for space investors, and to the extent possible, I think it is recommendable to include arbitration clauses in every possible space contract. And we can see that this is already widely the case. I think SpaceX, Boeing, Airbus, Philippe, correct me if I'm wrong, commonly include arbitration clauses in their contracts. So does the European Space Agency. And to anyone who is working on space contracts who does not yet include arbitration clauses, I think it's a good recommendation to maybe change that. Thank you.
Thanks, Laura. So, including arbitration clauses in commercial contracts obviously is one way to ensure that there's an adequate dispute resolution mechanism. But what about in the scenario that Ernie described, where there was the potential for collisions, right? And the spacecraft had to divert from its normal path, and that meant that it used more fuel, and that it, therefore had a shorter lifespan, and therefore, couldn't produce as much economic output over that lifespan. What is the remedy for an investor in that scenario?
This is, I think, one of the most difficult cases. Under very specific scenarios, you could maybe have a full protection and security claim against the host state, assuming you can prove a causal link between the damage suffered and any actions or failure to act by the host state. Obviously, arbitration will not be available unless the parties can agree to it after the facts, or in the improbable case that there is a contract between the parties involved in the collision. As we have seen, the Claims Commission is available through diplomatic protection for private operators, but its result would be non-binding, so it's probably not very efficient. But Timothy Nelson and another author that I just can't remember at the moment have written a paper a few years ago with the proposition that the awarding of launch licenses could be conditioned at a domestic level on the agreement to arbitrate any collision disputes, because the possibility of having an international treaty regulating this at the moment is very low because of the geopolitical context. But they suggested that if many of the spacefaring nations would agree domestically to include the obligation to arbitrate collision disputes in their launch licenses, then this could kind of, like, in a similar way as the bilateral investment treaties over time have promoted investment arbitration on a bilateral basis, this could maybe also happen with regard to space objects. But this is just an idea. It has not been implemented yet, but I think a lot of people are thinking about how we could make dispute resolution mechanisms available for those cases.
Okay, no, thank you, Laura. Yeah, I wonder also if international actors in this space might just simply resort to national courts on some sort of theory of extraterritoriality. The U.S. obviously has that concept, but perhaps it's a stretch to extend it to activity in outer space. I don't know if anyone, I haven't looked into that, but if anyone wanted to comment on that, you're welcome to. Otherwise, I wanted to give Ernie and Philippe a chance to comment on the importance of and mechanisms for protection of space assets from an industry perspective.
Well, just a word on extraterritoriality that you just mentioned, Ben. It struck me that one of the U.S. regimes that is extraterritorial in the US is the export control regime, the International Traffic in Arms Regulations regime. So that's a little bit different, but that would apply outside of the US and could be used by the US to enforce a number of things. I mean, I guess the question is, and based on my old days doing a little bit of international arbitration when I was in private practice, in the case that in the event that you are able to secure a decision in favor of your client, then there is the issue of how you secure the asset whenever the asset is owned, let's say, by a state or a government, right? I'm not sure if there has been any practical examples of that. Maybe Laura, you know one, or Pierre. I'm not aware of any, but it struck me as one of the issues that private investors will likely face in the near future.
Yeah. No, definitely. I think they face issues of sovereign immunity among other issues. So I'm looking at the clock now. We only have about 5 more minutes in our session. So what I wanted to ask all of our panelists about is, what's the outlook for the future in terms of risk and opportunities for private business activities? I'll start with you, Laura, and then we'll move around.
Yeah, I don't want to take much time, but I think another aspect that will become very relevant for satellite operators specifically will be frequency interference disputes and in general disputes over who will use which frequencies, because as the lower Earth orbit in general, the radio spectrum is also becoming very saturated. And again, I'm coming back to my point that I made earlier, coordination agreements between different satellite operators can contain arbitration clauses. And I think this would be a useful practice for for satellite operators going forward. There has been a case between Eutelsat and SES in 2012 on the basis of a coordination agreement. So I think Eutelsat does include arbitration clauses in their coordination agreements. I've recently learned that OneWeb, for example, does not, but I think it would be probably a good practice going forward. Thank you.
And Peter, I think you've already identified at least one future trend, mining the moon, but anything else?
Yeah, so I think, generally, the development of private space activities will drive the need for further legal rules that govern the area, and that's a big opportunity. On the international level, the Artemis Accords, for example, expressly anticipate that there would be a further development of those rules among the Artemis parties. So maybe what we will see over time is the development of that, let's call it, well, maybe not regional, but like this subset of countries that subscribe to the Artemis Accords might develop something that is closer to giving investors a remedy or guidance at least as to how to resolve situations like this when you have you don't have any contractual relationship. You have impacts caused by the space object of one country on the investors of the other country. So that's one. The other, I wonder, because the prospects of a global new regime for space investments, I think, are pretty much zero in the next many years. So I wonder if countries eventually will resort to like unilateral domestic legal regulation aimed at protecting their own nationals, such as, and this might be a stretch, but the United States might adopt something that would allow the imposition of sanctions upon the state officials of another country involved in acts that damage the space investments of U.S. nationals in space. Maybe we'll see.
Ernie, what do you see on the horizon?
Not an expert in this particular domain, but given that my emphasis is really around business and economic opportunities, insurance. There could be a rise in space insurance business. I mean, you can't register your car without having liability insurance.
No, that makes sense. And that may be one way to mitigate the potential for collision damage in that ever-crowded space. Philippe, do you have anything to add before we turn it to the audience for questions?
So just to wrap up, space exploration activities is a growth area, obviously, and especially human flights will require and will continue to require huge amounts of financing, hence huge involvement of private investors. So I think the topic is quite relevant. I concur with Ernie about insurance. That may be a separate discussion, but that's certainly a fascinating area, both in terms of technology, economy, and legal and regulatory regime. So thanks for the discussion, and hopefully it has been helpful to our audience. Thank you.
All right, thank you, Philippe, and thank you to all of our panelists. So Jose, you may have to guide me on how the next 15 minutes work, but I assume we're just going to take questions from the live audience and from our virtual audience. Okay.
And to the live audience, and just speak up. There's microphones everywhere, so just, identify yourself and if you have any questions, yeah.
Yes.
Hi, I'm Nick Rundler. Peter, and you both mentioned it that you implement national court remedy in the absence of possibility. And I've been thinking that Congress could enact new exception for the possibilities that would permit it just sparked in my head, but you can probably think of liability theory under common that you could assert as a jurisdiction So that might be a way, in the absence of a multilateral agreement to, codify the ability of investors to seek compensation for the U.S., which might have an interest in promoting its space industry, to kind of give forms for the rest of the.
Yeah, I think something like the Helms-Burton Act, but for space, is
right.
what you're thinking of. Very interesting.
Just for those following questions, could you come to the front so that they can hear you? Because apparently the microphones are around here as opposed to around there, and that was my fault. So sorry for that. Or if you want to rephrase the question so that everyone hears it.
I think the proposal was that from the audience was that Congress might enact a statute that would remove sovereign immunity for states that have engaged in activity in space that has negatively affected U.S. investment in space. So, and that definitely seems like it could be a possibility or one solution. Any other questions from the audience? If not, yes.
Do you want to come to the front so that they can hear you?
So I'm an Indian qualified lawyer. So my question is regarding, Laura mentioned a couple of pieces on essential security, which India has faced in the recent past. So I was wondering, going forward, when you have claims arising of regulatory measures where states will often come up with a defense of essential security, do you see a trend and how this could span out if it's not a state-owned entity which is running the operation, but a private entity, and for example, now it's been commercialized. So I want to know if essential security interest doctrine or the clause in itself has been changed from what it was before, or do you see the same trend which has been followed from the Indian side of
Laura, would you want to address that?
Could you repeat the question, because it's very difficult for the online audience, I think, also to hear.
Okay. So if I'm phrasing the question correctly, it comes from the fact that because there are more private actors in the space sector, and foreign investors may be dealing with an operation that is, I guess, managed by a private actor as opposed to a state-owned entity, would that have any impact on the interpretation of its essential security provisions in investment treaties? So I think reference was made in particular to the two cases against India that you had described.
Yeah.
Earlier.
So maybe Ernie and Philippe or anyone here knows more about this than I do, but from what I know is that most of the space contracts have provisions that in case of national emergencies, commercial operators have to hand over their satellite capacity to governments. I believe the US has such a provision, so do many other countries. And most commercial satellites, or all of them, are dual-use technology, so they can be used for military purposes or for national security purposes in general, if necessary. So I would think that this maybe answers the questions. Satellites are never just commercial, which is why one of the reasons why there's a lot of confidentiality in space contracts and space disputes, because of the military implications they can have. So this will be important, I think, both in investment and in commercial space disputes going forward.
All right, thank you, Laura.
I would just add, I think if I understood the scenario correctly, it would raise questions of attribution, because if I understood it right, it's basically a situation where functions that are or that were administered by the state or the state authorities are being privatized, and they are being, now done by private entities. And so in that case, the question would be, is it nonetheless a sovereign function that the private entity is doing, in which case, under the Articles of State Responsibility, that conduct still would be attributable to the state, and arguably the state still would be responsible for under investment treaties for whatever happens. I mean, the question whether issues of national security would come into play. Just not entirely sure that the answer to that question would necessarily change if a state privatizes a state function and empowers.
Okay, thank you, Peter. So we have a question from the audience. This is for you, Ernie, and it says, regarding the kinetic destruction of the Russian satellite, the question is, do you mean Cosmos 1408? Have there been any attempts on the part of owners of affected assets to recover damages, to your knowledge?
I am not aware of any sort of active pursuits of remedies to sort of seek recovery of, as a result of the damage.
So hence the need for insurance or a new statute from Congress. Yeah. Okay.
Maybe it also drives home the point that the thing that we currently have is perceived as not providing any remedy at all because nobody has tried.
Yep.
If I may add, I think there haven't been any proceedings because there haven't been any damages, but it's just that with ever more debris being created, it's a question of time, I think, until there will be damages. So that's why insurance is probably very relevant.
Well, it seems like from Ernie's description that there's already economic damage because the increased fuel usage that was unplanned shortens the economic life of the asset.
Yeah.
So perhaps the economic damage is not that significant.
Or difficult to prove.
Yeah, I mean, it would be the quantum of damage would be a sort of a very technical calculation. So I think it can be proven to say, hey, this is how much fuel I used, to essentially do the orbit raising maneuver and then return the asset back to its normal orbit. I mean, I think it can be done, but it's not just about the value of the fuel, it's about the value of the asset that's using the fuel. And how do you establish that? That might be a little more difficult. Right, no, exactly. I mean, there's, every time you sort of perform these type of maneuvers, there's additional wear and tear on the asset that was not originally sort of planned for. So, I mean, if you're reducing economic life, by, let's say 1, 2, even sometimes 3 years, I mean, some of these smaller spacecraft only last for 5 years, right? So, it's then, you then have to say, hey, I'm going to have to replenish the constellation. I'm going to have to launch, additional spacecrafts. There's a whole slew of things that's associated with this that sometimes not planned for. And I think that, the industry is slightly evolving in a sense that historically, because space has always been recognized as a very hard domain, there is a ton of margin built into legacy assets. 15-year contracted spacecraft have fuel on for like 18 years. You can fly for 20 and it will still work. But as we get more competitive with sort of the architectures of these space solutions, operators and manufacturers are looking for ways to sort of reduce cost and try to maximize their economic extraction based off of the life of just that spacecraft. So instead of giving you a 8-year spacecraft that was contracted for 5 years, you're really getting 5 years, and it'll break the day after 5 years. So that's the kind of things that we're sort of always thinking of. So when you have these sort of unplanned events, it really sort of puts a wrinkle into sort of the broader system architecture.
Ben, if I may add, one of the difficulties, maybe Ernie, correct me if I'm wrong, but it's that it's not always easy to identify whose debris is causing the maneuvers. So that's maybe one of the reasons. And the other thing is liability for damage in outer space, at least under the liability convention, is fault-based. So I think you would not only need to prove that the specific part of debris that has caused your maneuver came from that country or that company, but also that it was there because of a fault by that state. I guess in an ASA test, it would be relatively easy to prove, but if it was a satellite that was defunct and then broke up, for example, it might be more difficult to say that was a fault or fault-based liability.
And just to be clear, let me and do something here. And just to be clear, is the liability convention is a convention. It's only in states, and does it provide for disputes that may arise out of acts of private parties that are not in a contractual relationship?
So that would be a private to private type of event, basically.
Yeah.
Well, it's the idea is that it's either the launching state itself, or objects launched from its territory. So that could be a privately launched space object that causes damage. And on the other end, it is not only damage to another state itself, but also damage to property health and so forth of that state's nationals that is covered. So, it's the main problem is that it's the dispute resolution mechanism that's built into the treaty is purely state to state. It's mostly a diplomatic process. It's not enforceable. So in order for there to be a private to private claim, it would be akin to an espousal of a claim under international law. And, basically good luck with that if you are a private investor.
So as a follow-up on that, it's an area of the law that many of us who have discovered this area in the last months or years or so also discovered that space law has been developing itself for decades. It's not a new area of the law, yet there's so much space for creativity and filling in the holes. One question that I had, and I had written it on the chat, is whether you know of attempts to modify basic model BIT concerning provisions such as territory or provisions such as definition of investment that would make the BITs work. Because one of, and correct me if I'm wrong, one of the main conclusions is that a typical model BIT has a very limited use for this type of provisions. But as we all know, BITs are being drafted and redrafted and modified all the time. And I am not sure whether a BIT would be the correct instrument, but it seems that a state-to-state treaty with dispute resolution state-to-state might also have some limitations. I mean, I wonder whether that exercise is being done or tried, but
Well, I don't know the answer to that, but my instinct is no, because the current redrafting of investment treaties is trending toward reducing the scope of state liability, not providing more investors more opportunities to sue states. So I doubt that's happening, but maybe I'm wrong.
I have to say, I am not aware of any developments like that. I think it certainly would be open to states to agree to something like that. But I just am not aware that this would be happening. But I also wanted to comment on something that you just said, Antonio, which is that, it is true, space law has been there for a very long time. And, there are a number of people who have been studying it for a very long time. And I think what we are seeing now is that there is increased interaction between, state law and other areas of the law. I am one of the newcomers myself, and I'm finding this to be a very open and friendly community. So I'm grateful for that. I think it's a good thing that hopefully will be like mutually enriching going forward.
And I myself, I completely second that statement, because I'm a newcomer as well, so I'm very grateful to Laura and others that have been open to join, to allow us to sort of join and learn in this space.
That's an excellent note to end on, Jose. I think we're now out of time. I just want to thank our panelists once again, and thank you, Philippe, and thank you, Laura, who have dialed in. It was a really excellent discussion, and I learned a lot. I hope our audience did as well.
Thanks very much. Thank you.
Thank you all. I mean, thank you, Ben and all the speakers. The speakers who are now in person are relieved from their speaking duties, and if anybody wants to stay on for a few minutes in breakout rooms, feel free to do so. Just a few minutes, but do not feel compelled. So we will play by ear. During pandemic times, a lot of people were very enthusiastic to stay online. During transitioning times away from the pandemic, i.e. now, people have been or have become a little bit more timid. So we'll play by ear. So thank you very much for this great panel, and we'll see you at the next one, which I believe will be at 12 at noon. So that will be.
Thanks very much. Thank you. Take care. Thanks. Bye.